Thank you, Nabuje. And I would like to also thank Christian for inviting me to give this talk, this lecture. I mean, it was supposed to be in March, but then you have the lockdown and it had to be canceled and so on. But it turned out that it's actually a quite good moment for me to present my research, because I finished writing my dissertation quite recently. I'm still waiting for the defense, so I'm in this transition period. And it's a great pleasure to be here discussing it with you today, to have your input, to have your perceptions about my research. So thank you very much for that. And as Navajit said before, I'm going to present some findings of my PhD dissertation. Of course, it's a large work, so I tried to pick some more general conclusions that I think it's interesting for the perspective for the perspective that you have been developing in the lecture series. Here's the title of my PhD dissertation. But actually, before I start talking about the research in itself and the sources I analyze and so on, I would like to share with you a short story, actually not a story, more a personal account written by a very important and peculiar character in Brazilian First Republic, which I think is very representative of many things that I will be talking about today. So around the second week of November 1904, Afonso Henrique de Lima Barreto wrote a short note in his personal diary commenting on a revolt that was taking place in the city of Rio de Janeiro, the then federal capital of Brazil. The popular uprising that later became known as the Vaccine Revolt, Revolta da Vacina, was triggered by an order by the mayor of Rio de Janeiro, Pereira Passos, to make smallpox vaccination mandatory. And here in this picture, in this comic, you can see a cartoon of Oswaldo Cruz, which was the director of public health by the time, and which was the person responsible for enforcing this measure. And he was fighting the population. So in this cartoon, you can have an idea of the tensions that were increasing by this time. I mean, the revolt was thematized by the topic of vaccination, but the wave of discontent had deeper roots, which related to a series of urban reforms, escalating levels of social inequality in the federal capital and also in other places of the country. Political violence motivated by social and or partisan discontent would actually become quite usual in Brazil in the years to follow. The so-called Brazilian First Republic started in 1889, so just 1 year after the abolition of slavery in Brazil, and was declared after a military coup heavily supported by civil political elites. The proclamation was followed by the implementation of a presidential constitutional republic, replacing the previous Parliamentary Constitutional Monarchy that had been in place from 1822 until 1889. Since its early days, the new Republican government pursued ambitious reforms from all institutional and social sorts, aiming to, let's say, raise Brazil to the same level as European civilized nations. So you had new code, you had a new constitution, you had new branches for the judiciary, you had new urban designs for the federal capital, you had a new flag signed by the words order and progress. And these were some of the novelties that scored at this change in the political system. But these discursive shifts did not necessarily mean effective changes. As in any political discourse founded on the idea of a radical historical change, the ideological background that served as the basis for the creation of the Brazilian Republic concealed a series of continuities with past practices and traditions. Living standards and political participation had not improved significantly after 1889. Also, social inequality and racism were still fundamental issues in Brazilian society. Actually, this multiplicity of changes paved the way for the emergence of political conflicts that would compromise this false impression of social harmony disseminated by the governmental discourses. Just so we have an idea of how frequent political conflicts were, and also how frequent the repression of this conflict was, the National Congress declared state of siege 9 times throughout the First Republic. In 1891, in 1892 for 2 times, in 1897, in 1904, in 1917, in 1922 for 2 times, and in 1924, scoring 2,365 days of government under exceptional rule. So all these declarations occurred in contexts in which the president in office felt the need to protect the country from alleged separatist movements, or his personal term, from political opposition. It was in this atmosphere marked by profound political and social clashes that thousands gathered at the streets of Rio de Janeiro city center to protest in November 1904. Police repression, of course, was quick and harsh. Lima Barreto, a black scribe who also acted as a journalist and wrote many books, chronicles, and short stories about Brazilian society and politics during the First Republic, was probably on board a tram or walking along one of the streets where protesters gathered when the police took action. As he chronicled, the police apprehended anybody they met on the streets without any criteria. These people were taken to local police stations and then to the central police office. There they were violently and humiliatingly pushed around and then thrown into a large courtyard. When police managed to gather a dozen people, they sent them to the Snake Island, where suspects were beaten with no mercy. This was President Rodrigues Alves' terror. President Floriano Peixoto's was red, President Prudente de Moraes was white, and the one from Rodrigues Alves was colorless, with just trunk and coat. I find this description made by Lima Barreto very enlightening because it brings a series of elements that characterize most of the studies somehow addressing the way how state authorities repressed this and other similar political conflicts, not only in Brazilian First Republic, but also in other regions of the world and other historical periods in the modern and contemporary eras. The impression that responses were arbitrary, violent, draconian, illegal, exceptional, and that this was actually some sort of pattern, some sort of rule when it comes to controlling and repressing political dissent is something that we can find both in, for example, more specific studies about rebellions, revolts, and social movements written by Brazilian social historians, and also in more general legal historical scholarship on transnational regimes aimed at the repression of anarchism and political assassination in, for example, Europe, Latin America, and the United States. Of course, these studies come from very different backgrounds. They are based on very different research questions. They have very different sources. But I would say that the core argument they present is based on the idea that mechanisms of state protection against popular protests and violent political opposition either created some sort of separate normative regime, essentially formed by police, security, emergency, and/or military measures and laws, or that they were simply outside the rule of law in the sense that they not even had any sort of legal ground. In other words, constitution, criminal codes, and other laws that were enacted according to a more or less standard lawmaking procedure would not give it the grounds or the guidelines for legal responses to political conflicts, either because their provisions prioritize individual instead of state protection, or because they were simply unable to offer functional solutions in terms of power and in terms of speed to solve political contingencies. What I basically tried to show in my PhD research was that both Lima Barreto and the studies dealing with the state responses to political conflicts in the modern contemporary era, both in Brazil but also in other places, they are indeed right. The repression of rebellions, revolts, strikes, and political violence, more broadly speaking, provoked the creation of a complex set of laws, extra-legal and/or extrajudicial measures that challenge basic principles of modern justice systems all over the world. But my efforts were mostly dedicated to show that episodes of political conflicts also pushed great efforts made by a broad variety of actors to adapt existing laws and legal categories to political contingencies. Existing laws, existing procedures, and existing crimes were constantly being used and negotiated in court cases thematized by political conflicts. And this was, let's say, the main finding and the main impression I got from my research. In a scenario marked by this multiplicity of political conflicts that were strongly repressed by state authorities, Instead of focusing on, let's say, extraordinary measures like state of emergency, like martial courts, like emergency laws, practices of expulsion and deportation, I kind of did the opposite movement. I tried to see how existing criminal law was being used in the repression of political conflicts. And here I'm referring mostly to the Penal Code of 1890, which was considered to be a quite liberal one for the time, and how these so-called extra-legal or extrajudicial measures influenced the way how codified criminal law was being negotiated in courts. So for that, I analyzed several criminal court cases tried by different courts and focused on different types of political conflicts to ask questions related both to the space occupied by criminal law in repressive policies and to the uses and interpretations generated by specific actors and circumstances. Was criminal law commonly used as a legal response to political conflicts in Brazilian First Republic, and if so, how and when? What were the main legal concepts and categories used to criminalize political dissent, and what were the meanings assumed by them? So I would say that these were my main concerns when reading and extracting information from my sources. And this is also something important to be said, because as I mentioned before, when I was talking about the studies that somehow addressed legal responses to political conflicts, you have strong traditions coming mostly from social history and legal history, but they do not usually use criminal court cases as sources for understanding what was law and how it operated in context of political contingency. Social historians who dealt with the repression of political conflicts indeed used to resort a lot to court cases, to criminal court cases more specifically, but they usually are more focused on agency and on how claims or how legal claims can be telling sources of broader social dynamics. On the side of legal historian, there's a general lack of studies based on court cases and a general tendency to focus on more standard legal sources such as laws, doctrines, legal journals, and so on. So this is something important about my work as well. It is a legal historical work, as you can see from my research questions, that attempts to propose an approach to law that does not separate theory from practice, but instead sees court cases as sources where we can understand normative production and normative appropriation in more local situations, in more local contexts. So in this case, I would say that I did not study the application of criminal law, but instead what was criminal law when it comes to the repression of political conflicts in Brazilian First Republic. Of course, as I said before, we had in Brazil a broad variety of political conflicts ranging from local revolts led by former slaves, military revolts led both by high-rank and low-rank militaries. You have civil wars with separatist claims. You had massive strikes. So it was not an easy task to choose the cases I would analyze, and most of all to choose which cases would be more adequate to answer those questions. Archives were, of course, the first filter. I did not go to local archives, so my sources were pretty much coming from the Brazilian National Archives and the archive of the Museum of Justice in Rio de Janeiro. And within the material I could find in these archives, I decided to focus on the material that addressed conflicts that had a national scope, meaning they were perceived by the media and by state authorities as being not only a local threat, but also a threat to the whole Brazilian federal state. And I also went to the cases that were most representative either of prototypical types of political conflicts taking place not only in Brazil, but also in other countries, and of legal strategies that were commonly associated to justice and administration in cases of political conflicts. I also heavily relied on newspapers because it was quite usual that Brazilian newspapers published petitions, decisions, sentences, and that they provided a very detailed cover of court cases. So newspapers worked for me both as a thermometer to measure the impact and relevance of a given political conflict and as sources to gather information about specific court cases. Anyway, to start making things more concrete for you, in my first chapter, I analyzed several habeas corpus procedures conducted by the Brazilian Federal Supreme Court throughout distinct periods of the First Republic as a way of detecting general patterns related to each political conflicts were entering the judiciary and how they were legally framed. Although habeas corpus procedures were not technically defined as criminal actions during the First Republic, It was a constitutional remedy heavily used by people affected by repressive measures such as apprehensions, detentions, expulsions, deportations, and so on. For that reason, they are very good sources for detecting if, when, and how criminal law appeared in the dynamics of repressing political conflicts, and for seeing what were the legal logics used to conciliate criminal law and extrajudicial or extralegal measures. The second chapter was dedicated to a criminal court case representative perhaps of the most classical format of political violence, and the assassination attempt against political leaders. It addressed a group of politicians and military that allegedly plotted to kill the then president in office, Prudente Moraes, in 1897. The third chapter was thematized by a general strike taking place in São Paulo City in 1917, and the criminal court case generated after the apprehension of one of its main leaders, Edgardo Henriot, a well-known journalist, writer, and publisher who created and edited several anarchist newspapers in Brazil during the early decades of the 20th century. National industrialization, continuous immigration of Western Europeans to major Brazilian cities, and the consolidation of the workers' movement formed the background for a criminal court case that attracted great intellectual and mediatic attention. The fourth and last chapter covered the Fort Copacabana revolt, a military revolt that took place in Rio de Janeiro as well in 1922, and which involved a large group of military people fighting to prevent the president-elected, Arthur Bernardes, from taking office. I cannot enter the details of each and every case, and if you want, we can talk in more detail about the cases after my presentation. But what I would like to present to you in more detail are the patterns regarding the legal logics and the legal concepts of criminal law that I could see in these cases. Even though they address very different periods within the Brazilian First Republic, and even though they have very distinct social actors as protagonists, so you have militaries from diverse ranks, you have the labor movement, you have immigrants, you have opponent groups within the Republican Party, and so on, they all incorporate several general patterns regarding the way how criminal law was being used and negotiated in courts. The first of these patterns that I would like to share with you is that all the cases I analyze provoked the declaration of a state of siege aimed at the quick neutralization and repression of rebel forces, but at the same time, they generated extensive criminal court cases intended to prosecute sometimes only people perceived as ringleaders, sometimes large groups of alleged supporters of the rebellious movements according to standard rules of criminal law and criminal procedure laws. The prosecution of these criminal court cases usually took years to be concluded, and the outcome was in overall favorable to the accused. They were either absolved by a grand jury, or the case was closed to the great amount of time elapsed between the commitment of the crime and the final trial of the case. But their own existence is something that already indicates that criminal law had an important role in the repression of political conflicts. Criminal court cases had the power to legitimize measures taken during a state of siege or a state of emergency, and to justify their extension even after this measure were no longer valid. For example, if somebody was apprehended during a state of siege accused of supporting or taking part in a revolt or in a strike, the existence of a criminal court case against this person would work as a legal justification for transforming this temporary detention into a legal detention that could be sustained for a very long period. So for this reason, apart from criminalizing political dissent, criminal court cases also proved to have a great strategic role in fighting criticism against state authorities. They were a way of showing that violent and draconian measures taken during the state of emergency were not necessarily illegal or incompatible with a liberal justice system, but instead could work as complementary elements to it. The second pattern is the more intrinsic one, let's say, and it has to do with the legal categories of crimes that were usually discussed and used within these criminal court cases. If you see the description of the conducts for which actors involved in these conflicts I analyzed were being accused, it is quite clear that they would be legally framed under crimes that both existing laws and the doctrine at the time used to define as political crimes. So in the case of the assassination attempt against the president in 1897, for example, you clearly have a narrative that would follow under the crime of conspiracy. You had a group of political opponents that were accused of organizing meetings to gather support for a plan to kill the president and to find a person that would execute this plan. The chief police officer that investigated the case actually concluded the report by saying that the people he arrested and heard in the police station had committed the crime of conspiracy. But then if you look at the content of the criminal court case, you see a large debate between distinct judicial authorities in order to change the legal classification proposed by the chief police officer so the conducts could be classified as common crimes instead of political crimes. In this case would be homicide attempt and serious injuries. Each authority mobilized distinct arguments to justify this change, but to make a long story short, who ended up deciding this issue were the justices at the Federal Supreme Court, who agreed that the group of political opponents that tried to kill the president committed the crimes of homicide attempt and serious injuries. Their justification for the decision, however, was not grounded in technical arguments based in laws or doctrines, but instead in the fact that a group of people that tried to kill the most important person in the country should get a severe and exemplary punishment, and therefore they should get punished for the crime that would prevail longer and harsher penalties. According to the Brazilian Penal Code of 1890, the crime of conspiracy was punished with imprisonment for 1 to 6 years. The crime of homicide with imprisonment for 12 to 30 years. So this movement of disputing the crime and the legal categorization of the crime for which suspects were to be accused and ending up deciding for common crimes instead of political crimes, either because they provide for longer and harsher penalties, or simply because they are a way of depoliticizing the procedure, is a quite common one in all criminal court cases I've analyzed. And this is very interesting because it demonstrates that sometimes laws and crimes that were not specifically enacted for or aimed at the repression of political conflicts could also provide solutions that were more aligned with broader political and social dynamics that were also very important for the development of the case. The third and the last pattern that I would like to share with you is very much connected to this issue of the legal categorization of crimes and regards jurisdiction, meaning the court where the cases would be prosecuted and tried. In Brazilian First Republic, you have several jurisdictions where a political conflict could potentially be prosecuted and tried, depending on who was being accused and what was the crime for which this person or these people were being accused for. So you had laws, for example, determining that military people should be prosecuted by the military courts in case they committed a crime, or laws that established that the prosecution of political crimes should be performed by the federal courts. But in the court case records, you can see that actually jurisdiction was a quite controversial issue that was also constantly being debated by prosecutors, lawyers, judges, and by the accused themselves. One of the reasons for that is because, as I said before, the own legal categorization of the crimes for which people involved in political conflicts would be prosecuted and tried was under dispute. Defining a given conduct as a common crime, a political crime, or a military crime was also a way of defining which courts would be competent for dealing with the case. Or at least that was what legislation determined. But by reading the court cases, we realized that things could actually be a little bit more complicated than that. The case I've analyzed in my fourth chapter, for example, the criminal court case of the Copacabana Fort Revolt from 1922, a military revolt for which hundreds of military people were initially accused, is, for example, a case where these complications regarding jurisdiction appear quite clearly. The fact that almost all the accused were military should make the issue of jurisdiction quite an easy one to solve. The Army Penal Code from 1891 made it quite clear that military personnel should be tried by a military commission when committing any of the crimes predicted in the code. The content of the Army Penal Code, in turn, was quite similar to the Penal Code of 1890, so pretty much every crime present in civil legislation was also predicted in military legislation. But as it turned out, sending the suspects to a trial in a military court would also mean to send the case to a more restricted arena, where public attention would be more controlled and less acceptable. If the case went to the federal courts or to some local court, media coverage and public presence could help building a case against the suspects, so they would not be seen as national heroes or public martyrs. Another option, therefore, would be to somehow shop for another forum for the case and resort to a civil court instead of a military court. And that was what the justice at the Federal Supreme Court ended up doing after trying a habeas corpus petition presented by one of the accused in the case. They decided that the crime committed by the rebellions was not military, but instead a political crime, and therefore it should be prosecuted and tried by the federal justice, meaning by a civil court. As I said before, court cases had a very strategic role in fighting criticism against state authorities. And the place where the cases would be tried were also an important part of such a strategy, as I could see in my cases. So I would like to start wrapping up and going to my conclusions. I mean, these three patterns that I've detected in the court cases I analyze. So the very existence of the criminal court cases, the constant use of common crimes instead of political crimes to prosecute and try people accused of taking part in political conflicts, and the kind of reverse social forum shopping dynamic that determined the jurisdiction indicate in first place that codified criminal law was a very relevant and strategic legal response to political conflict, despite other emergency, security, and police measures that were activated by political dissent. In second place, it shows us that legal concepts from criminal law were highly negotiable and adaptable to political and social contingencies, and that this was not necessarily incompatible with the rule of law. And these conclusions do not apply only to Brazil in the First Republic. I believe that these patterns I detected can provide elements for understanding the interactions between criminal law and politics, not only in the Brazilian First Republic, but also in other places and in other historical periods. Although the court cases I analyzed addressed localized conflicts of mostly national concern, they mirror several debates, practices, and forms of political violence that were taking place in a similar fashion in other regions of the world at the same period. Instead of representing a sign of foreign influences or transplantations, this characteristic can be seen as an example of how local experiences shaped and mediated global processes of normative production and appropriation. So in making this argument, apart from an analysis of specific uses and interpretations of criminal law, I try to offer a non-Eurocentric perspective on a topic that is usually presented as of transnational or global dimensions, the legal responses to political conflicts. And also by focusing on criminal law adjudication rather than laws, administrative, police, security, and other sort of exceptional measures. I also tried to provide an analytical framework through which law can be seen as a process of cultural translation that at the same time comprises theory and practice. So I think that was pretty much what I had to say. I'm happy to answer any questions and comments that you might have. Thank you very much.